On Election Day, November 2nd, while most Americans are at the polls, the 9 justices of the Supreme Court will actually be hearing a very important free speech case called Schwarzenegger versus Entertainment Merchants Association. And what this is a test of a 2005 California law that prohibits the sale of violent video games to minors. In 2005, Governor Schwarzenegger signed this law that said that all video games have to be labeled in terms of their violence level, and that anyone under 18 could not buy one of these without parents' permission.
People may think that video games are just for kids, but that's not the case anymore. In fact, the average age of a person who plays video games is 34. The average buyer of a video game is typically 40. So the games have to reflect the consumer.
He will fight savagely. I have full confidence in your courage, devotion to duty, and skill in battle.
Everybody has a different opinion of what violence is. For instance, Medal of Honor, graphics are getting more and more realistic, where sometimes it approaches a movie. They are still almost animations. They're trying to make it realistic, like combat.
Damn it! We gotta get the wire clear!
Well, the industry, the software industry and the Entertainment Merchants Association sued immediately, blocked this law from ever taking effect, and said this violates the First Amendment rights of the industry and of anyone who would purchase these video games. The state of California lost in lower courts, both the district court and at the U.S. Court of Appeals for the Ninth Circuit. The Ninth Circuit ruled that indeed this did infringe First Amendment free speech rights.
Game here, which is actually mentioned in the Supreme Court case, Rainbow Six. You can see it has a little M on here.
Rated M for mature.
And it says recommended for 17 and up. There are other ratings also. There's E, meaning for all ages. There's a E10, which means recommended for ages 10 and up. There's a teen for teenagers 13 and up. M is 17 and older. These are recommendations. This is a voluntary system that the game industry and the retailers decided to adopt I think about 10 or 15 years ago, basically because Congress brought up this whole idea of violence in games.
The Supreme Court decided to take up the appeal. So on Election Day, November 2nd, they will hear arguments from the state of California saying violent video games do not deserve the same First Amendment protection when they are being sold to minors. The software and entertainment industry here is saying the notion of violence is a very fluid one. The state law is very ambiguous. It's hard to tell what's actually targeted here. But the Supreme Court is giving California a shot to try to defend its law.